The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. And I also particularly want to welcome the American Government class from Lamar's Community High School. I'm glad you're here. And Mr. Zeke, thank you for having the students with us this morning. I hope you enjoy it. We have 3 cases that are submitted this morning. Those cases are State of Iowa versus John Green. Second case is the estate of Michael G. Cox. The second versus Dunakay and Clott. The third case is Simon Seeding and Sod versus Dubuque Human Rights Commission. The last case is now submitted to the court on brief without argument, and we'll hear the arguments in State versus Green. Ms. Nye.
May it please the court, counsel. My name is Melinda Nye, and I'm here representing Mr. John Green in his direct appeal from his conviction, judgment, and sentence for second-degree murder. This case, Mr. Green's case, raises 2 important issues. The first being whether his right to counsel under the Iowa Constitution had attached at the time of his interrogation on March 25th, 2014. And secondly, whether the instructions given to the jury defining a dangerous weapon and informing the jury that it could infer malice from the use of a dangerous weapon were improper and prejudicial under the circumstances of his case. On the constitutional issue, my plan is to take these in order. On the constitutional issue, this court recently decided Sen less than a year ago, and after the case was briefed. This case was briefed, but in Sen, the court was faced with a similar related issue regarding when the right to counsel attaches. And so in this case requires court to sort of revisit Sen and decide that broader issue about what it takes for a right to counsel under the Iowa Constitution to attach. And specifically, we argue that the determination of when a criminal prosecution begins, when an investigation has been transformed into a prosecution, and when a suspect becomes an accused, must be determined from more than just whether formal charges have been filed against a person, but rather should be determined by looking at a totality of the circumstances, taking a broader look at what it.
Well, in Sen, there was an arrest in that case, wasn't there? There
was.
And here, of course, there was no arrest.
There were no arrest and no charges filed until immediately after the interview.
Under the test, what's the linchpin of when someone would become an accused?
I think both. When you look at how the court divided in Sen and how the U.S. Supreme Court applies the Sixth Amendment right to counsel and determines when a criminal prosecution has begun, the linchpin has to do with prosecutorial involvement, and that's why that line has been drawn right now under the Sixth Amendment.
What kind of involvement would it take?
I think when you've got the prosecutor questioning the defendant, that's the sort of heavy.
But in the federal system, people get pulled in front of the grand jury all the time and questioned by the prosecutor, right? They don't have a right to counsel.
That's under the federal system.
You just told us you want some incorporation of this federal idea of when charges have been commenced.
Excuse me, that's not what I meant. But I meant.
And I didn't mean to mischaracterize what you said.
I think sort of part of the underlying rationale for drawing the line at the formal filing of charges. One of the reasons that the line's been drawn there and has to do with that's when the prosecutor gets involved, and we see that in Jackson when this court tried to apply the Supreme Court's test, and it looked very specifically at how involved was the prosecutor in getting the warrant and filing the charges.
What does the record show here? And let me preface it by saying this. It seems to me there's degrees of prosecutorial involvement. I think it's fair to say that law enforcement officers can consult with the county attorneys all the time. In some jurisdictions, before you get a warrant, for example, you know, they check in with the county attorney on the warrant. So that's one kind of involvement,
Right.
relatively common. On the other hand, at the far extreme, we might have a much intenser involvement. And I guess my question to you first is factually, what do we have here? I mean, I understand that the prosecutor flew down to Florida, which is fairly exceptional, and participated in some fashion in the interview. But we don't know, at least I don't know, exactly to what extent the prosecutor was really directing the interview. Was he there just to kibitz a little bit on the side? So make your compelling case that this isn't a tangential involvement of the prosecution and that this really was a focused prosecutorial effort.
As you stated, sort of the most compelling fact is that the prosecutor, the county attorney, flew to Florida, flew 1,500 miles on the taxpayer dollar.
Yeah, but it's true enough, but that doesn't show pressure against the defendant. The fact that he flies around, he can fly around wherever he wants. You know, the question is prosecutorial overreach, and the mere fact of flying down to Florida doesn't overreach much of anything. The participation in the interview might, and so.
Right, so he's in the next room or close by watching the interview on closed circuit television. The officers that are conducting the interview step out of the room multiple times, consult with the county attorney, find out questions to ask, find out how to focus or steer the questioning, and come back into the room and then ask the defendant those questions. He's the one who makes the decision when to file charges, when to arrest. That's in the suppression hearing the officers were questioned about. When did you know you were going to arrest him? And they said, "Oh, that's not our role. That's the county attorney."
Was it a custodial interrogation?
On the facts of this case, we don't have custody. It was voluntary.
Does that make it? Is that a factor we should consider?
I think that should be a factor to consider. We don't have that. I mean, he was in a police station. It was a closed room, but it was litigated below and not raised again on the appeal.
Ms. Nye, what if the prosecutor would have remained in Iowa, but gave the police investigators, very detailed instructions on how to interrogate? Would that, and then they go down and interrogate Green, would that amount to Green becoming an accused?
Possibly. It depends on the level of detail, how it was, how things were going, what the rest of the circumstances would. But that would, that would be an argument. Certainly.
How is the state supposed to apply this test and figure out when it needs to provide or offer to provide a lawyer to people?
First of all, it was suggested that maybe if the county attorney's there and can tell the defendant himself that he has a right to counsel, that probably means he needs to. But it ends up being a totality of the circumstances, and police have to do that all the time right now when they decide, is this a custodial interrogation? Is this a voluntary statement? They already make this sort of determination. So if we, apply this sort of test,
Under your standard, in effect, in this non-custodial situation, you're claiming your client should have been Mirandized, right?
Just informed. It's not Miranda, but it's.
Well, right to counsel means you need to be told of a right to counsel and that a lawyer will be provided. So at least that part of Miranda, maybe not the informed of the right to sell.
Exactly.
But yet, if this person, but yet if the person had been arrested, then but there was no lawyer, but if the lawyer, excuse me, but if the lawyer had conducted the investigation, but no, there was no, I'm sorry, I misspoke. Go ahead. I'm mixed up. Go ahead, proceed. My bad.
The other facts that point that this was more than just an investigation, the prosecutor's involvement, he's sort of directing this from behind the scenes. As well, we know at the time, and I think these are other important factors, there were no other suspects. John Green was the focus. They knew, the officers testified that they knew that whoever was responsible was the person who'd been living with Mr. Koster at the time of his disappearance. They had, by the time they flew to Florida.
Can I interrupt for a second?
Yeah.
Why aren't the Miranda rights sufficient? You know, that's a Sixth Amendment. It's based on the Fifth and Sixth. If you read the original Miranda, it is the Sixth. Why aren't the Miranda protections sufficient enough to protect your client? I mean, he could have walked out of that interrogation. He could have done whatever he wanted. I mean, why do we have to come up with some artificial rule when the prosecutor's present or when the prosecutor's directing it that we need to go beyond the custody analysis in Miranda?
There are similar concerns, but the problem is that it's the prosecutor. This is the state, the machine of the state, the chief prosecutor, the county who's going to prosecute.
But in Iowa, most police officers complaint. It's not filed by the prosecutor.
Right.
So you can make the same analysis that whenever a policeman interrogates someone who files the complaint to charge them, it's the same thing. So I think if you take your logic to the end, anytime someone is being questioned with someone with charging power, they need to have an attorney. And I don't know if that's right or not. Tell me why.
I still think it's different when it's the prosecutor, when it's the county attorney who is sitting back there. He knows he's got an eye to the trial. Certainly police are collecting evidence to be used in a trial, but he's got an eye to the trial. He's a prosecutor. Police are still their goal. They may end up charging, but in theory they're following the investigation where it goes. When you've got a prosecutor, the prosecutor's looking to convict, and he knows what boxes he needs to check and how this is going to play at trial and what evidence. And so it's a different sort of gathering.
Aren't police these days just as sophisticated when you elements of crime and what charges to file?
Some of them, I'm sure.
Well, they read Fred Imbaugh, right? Fred, right? I mean, coming right out of Miranda, Fred Imbaugh was actually a law professor and wrote some interrogation techniques, criticized somewhat in Miranda. So, I mean, police are trained in interview techniques. I take it. You go out to the law enforcement academy. They, I'm sure they do. So, tell us the difference between a police officer who has read Fred Imbaugh. I mean, for example, in your brief, you said, well, they said that DNA tests had come back and identified him, and so forth and so on. I think that was one of the techniques that was inappropriate. That comes right out of Fred Imbaugh, I think. So tell me why it's different, and kind of building on Justice Wiggins, between a police officer who's read Fred Imbaugh and the professional prosecutor.
Again, it comes down to the sort of that the prosecutor is the expert adversary, is an attorney, knows the legal system, knows the trial. You can still have a smart police officer who's
Building on Justice Apple's question, police officers are allowed to lie when they interrogate people. A prosecutor really can't do that under his or her ethics. I mean, the police officer is more of a threat to a defendant about getting information on him with somewhat suspect manners, but they're allowed. So you would think that these protections you want would be more applicable to when a police officer is doing it, because they can do everything where a prosecutor who is a licensed attorney is bound by his or her ethics, to treat people fairly, to seek justice, not to misrepresent the people, things like that. So it just seems incongruent to me. I mean, am I wrong? Or?
Again, the fact that there are different ethics rules for prosecutors shows that the role of the prosecutor is different, and that they recognize the sort of power imbalance, and that sort of plays into a recognition that a prosecutor is different, that when the prosecutor's the one doing the questioning, that's a different case than the officers.
Let me ask this question hypothetically. Supposing the prosecutor was there but did not participate, I mean, just watched on TV, and then after the police interrogation filed a complaint, would that be a problem?
I think that would be less concerning, yes. And I think that would fit more in with, with Justice Katie was saying about, all the time you have cops, ask questions and consult with the county attorney along the way. And so if you have a county attorney who's not really actively involved, that's less, much less concerning than one who's pulling the strings from behind the curtain. And
Let's go to your second argument, if you don't mind, on the instruction.
oh yeah.
In the few minutes you have left. We consider instructions as a whole, of course, right? I mean, it's, you
Yeah.
pointed out instruction 19 and 20, I think. I understand your argument. But the jury was instructed that with respect to murder, that there's a malice element and so forth. So in the totality of the instructions, why isn't it sufficient to ensure that the jury didn't skip over malice aforethought?
I think there's sort of two problems when you look at the jury instructions as a whole. First of all, the malice inference, we know that malice inference can be rebutted by evidence of justification, and that's not made clear in this instruction. So that it leaves off sort of the second half of the law that applies in this case. If I may finish. And then also the fact that the jury's already instructed under the malice definition that it can infer malice from the surrounding circumstances, from the means used to commit the crime. And so the jury's given the broader legal proposition without focusing in on a specific piece of evidence that supports the state's theory of the case. And so it's redundant in that way, but it's redundant in a way that sort of feeds it to the jury and gives it with the judge's blessing. Like, here's this really important piece of evidence, and we already told you could infer malice, but now you can infer it. Just remember, you can infer it by the use of this dangerous weapon. But I think the fact that importantly, it doesn't explain how you consider the malice inference with the justification defense, how those two play together is where it can be misleading and confusing to the jury.
Thank you,
Thank
Counsel.
you.
Ms. Chambers.
May it please the court, counsel. This case presents a hypothetical question posed by the plurality opinion in Sen, and that is, if the right to counsel applies pre-formal charge, where does that end? Mr. Green would have that end prior to arrest, prior to charge, and frankly, prior to probable cause. And that very claim shows the problem with applying the Sixth Amendment or Article 1, Section 10.
You have probable cause for the GPS warrant?
There was.
There was probable cause to assume that there was a crime being committed by Green?
There was, actually that warrant isn't part of the record, but there would have been probable cause based on the fact that there was evidence that a murder had been committed, and that this person might be someone who had information
So
about it.
there was
So it could really be a material, yeah. He would have been at least a material witness, probably. But honestly, in this case,
The
Mr.
warrant
Green-
application suggests he was a material witness. Is the warrant application even part of the record? I'm not
I
even sure.
have not seen it, so it indicates to me it's not. I mean, it wasn't linked to the case anyway. At the time, Mr. Green was dead for 3 years before they found his body. And so the police and prosecutor were faced with the situation of trying to figure out who the suspects could have been. And they frankly just tried to gather a list of people the defendant knew because he had a relatively limited social life, and just started down the list. They talked to some people in Iowa. They went to Missouri to talk to a person there whose name was Tom, and who I think was the original suspect, frankly. And when he didn't pan out, then they followed a lead to the defendant here. But had he not confessed, they would not have been able to charge Mr. Green with this crime. So we not only have pre-charge, we have pre-grounds to charge.
It's kind of extraordinary that the prosecutor flies down to Florida, isn't it? I mean, I don't think that shows pressure directly, as I indicated in counsel, questioning with your opposing counsel. But it does suggest, to use the phraseology of some of the dissents in the Supreme Court, that there was a focus on the accused.
I think it really demonstrates the problem with trying to figure out when a prosecutor has been involved to the extent that it becomes the equivalent of a prosecution. No disrespect intended to the prosecutor here, but the fact that he flew down may have as much to do with the fact that it was March in Florida as it had to do with the need for him to be there. More realistically, I think it might well have had to do with the fact that they were interviewing a witness out of state. So if they developed probable cause to arrest, even to finding a room where they could interview the defendant, the suspect at that point, there were lots of out-of-state things that could come into play. Our officers can't, for example, directly arrest him there. We can't directly file the charge there. Iowa would have no ability to appoint an attorney to represent a suspect in Florida. So there are lots of interstate conflicts of laws and choice of law issues that may explain the prosecutor's presence there. Because if, in fact, he confessed, things were going to happen pretty fast. And his presence there would be helpful.
What's your view of his involvement in the interrogation? I mean, your opposing counsel says, well, I mean, they were kind of ferrying back and forth. I don't think the record tells us in great detail exactly what was going on, but I think it's fair to say that, and I want you to push back if I mischaracterize the record, but I think it's fair to say that the prosecutor was significantly involved in the interrogation, surely. Do you disagree with that characterization? Or?
He was certainly involved. I wouldn't say it's unusual to have the prosecutor watch an interrogation or be consulted during the course. Uncommon, perhaps, mostly, for the most part, frankly, just the crush of business. Prosecutors don't have time to watch interrogations. But this is a small county. This may be the only murder they've had in 50 years, for all we know. And so there's a lot of reason for the prosecutor to be more involved than they would be, say, in Polk County.
Would your view change if the prosecutor was in the room participating in the questioning?
Not in this case, and here's why. All of the talk about the involvement of the prosecutor and whether the forces of the state have focused on the suspect, those were all used to determine when between the time charges are filed or an arrest is made and when the indictment or information is filed, in that window, whether we've actually got a formal prosecution. So those factors the prosecutorial involvement is a factor to determine whether there has been a commitment to prosecute. Those factors have never been applied pre-charge, pre-arrest. So to that extent, I don't think it really matters what the prosecutor's involvement was prior to the arrest or charge. And now
really?
I forgot the question,
supposing the record showed that the prosecutor was intent on charging, and let's suppose there was a written memorandum of some kind. I mean, it's some clear evidence that the prosecutor was going to charge, and he says, let's get in an interrogation before we file. Now, that would be a problem, would it not?
I'm not sure that it would under the Sixth Amendment.
You would almost certainly... It'd be a problem with me, I tell you.
Okay. You would almost certainly have custody, I mean, under those circumstances. It is a practical matter by the time, and you also might have a statutory right to counsel. But remember, the Sixth Amendment is intended to ensure a fair trial. And for those reasons, it is only applied once the prosecution has begun. In that extraordinary situation, one, I would never advise a prosecutor to do that.
And I know you wouldn't.
And two, I don't think most prosecutors would, for the reasons that we talked about earlier. They're ethical constraints.
But the whole problem, I mean, and I understand the court's divided, and we understand that. The problem with just the formal filing of charges is subject to manipulation, at least. I mean, that's why some members of the court and some members of the Supreme Court have focused on a functionality test to avoid that. Let me ask you this. I mean, you've read the opinions in Sen. Assume that we adopt a functionality test of some kind. I want you to address your argument to the views that I've expressed and convince me that I should not go with the defendant here, that in fact, under the facts that are presented here, there wasn't a focus on the accused. Even applying a functionality test that Brennan might have applied in Kirby, et cetera, et cetera.
Okay. So let me start with one more narrow point, and then I'll branch out. In the cases that we see on appeal, because we generally see the more serious cases, the arrest is usually the culmination of the investigation. And so, yeah, the prosecutor can, if he or she chooses, kind of finesse when that's going to be filed. But typically, it's the end of the process. They investigate, they get probable cause, they're done with their investigation, they arrest, they charge, they have an initial appearance. But in the vast majority of cases, that is probably not true. In your average misdemeanor, for example, the arrest may be the first step of the investigation. Just to use the ubiquitous bar fight example. So the police are called to a bar fight. The first thing they do is arrest the combatants to freeze the situation, eliminate the danger, and keep the guys from leaving the scene. I'm going to say guys because it typically is. So in that situation, then, if under the functionality test, clearly investigation has focused on them. Clearly there's going to be a prosecution of somebody, although it might not be clear which of the combatants are ultimately going to be charged and prosecuted. So in that functionality test, there would be a right to counsel right then, right there in the bar. And there would therefore be no investigation, because no competent defense attorney is going to say, yeah, you're drunk, you just come from a fight, go ahead, talk to the police.
When they're arrested, they are entitled to a right to counsel under Miranda, at least the
Only if
warnings,
it's a
because
custodial.
they're in custody as soon as they're seized there and handcuffed before they could talk to them. So they are entitled to the right to counsel there. So Miranda takes care of that situation.
Miranda only talks about interrogation. Miranda only talks about custodial interrogations. For example, the police officer may want to say, let's do a lineup to some witnesses. There are lots of investigations they could do where Miranda would not apply. And, but sure, Miranda's going to kick in before the Sixth Amendment, generally. That's kind of my point.
As soon as they handcuff them, they give them their Miranda rights. I mean, that's common, and I want an attorney.
Mm-hmm. And
They
can waive
can't
it.
talk to them anymore.
But there are lots of, but Miranda, again, the Fifth Amendment is restricted to interrogation. So the Sixth Amendment is broader in terms of the things it applies to.
That was the issue in Sen, because there wasn't an interrogation, but the
Right.
person had been arrested,
Right.
was in custody.
There sure is a lot of interplay between the Fifth and Sixth Amendment and the Due Process Clause. All of those things are coming into play, but they're going to apply differently in different situations. But I think we should, in terms of our functionality analysis, we should not assume that arrest is the final stage in the investigation. And frankly, the involvement of the prosecutor is oftentimes a commitment to investigate and not a commitment to prosecute.
Why would it, if I understand it right, there were like 7. Do I have the number wrong? I mean, there were 4. I mean, there were 4 local police officers.
Oh,
and-
yeah, if you count the locals, yeah.
Right. That strikes me as a little odd as part of an investigation. That 7. My number may be wrong. Is it 6? I mean, the prosecutor.
It's a lot. There was a DCI agent, 2 local officers, and then I think 3 or 4 Florida officers.
Wow.
Yeah, it's unusual. It certainly is. Of course, we don't determine how many Florida
Well, I understand that,
officers,
but it doesn't. It seems a little less like an investigation. We're going to ask a few questions. It seems a little more like. I mean, it's a lot of muscle.
It is. This is a really kind of unusual case because it's happening out of state. So what would have happened is the prosecutor would have called down and said, hey, we have a suspect down there we'd like to interview. Could we use the law enforcement officer? And by the way, we don't really know what's going to happen when we arrive at his trailer. Could be fine. He could be just there with his little dog and agree to go with us, or there could be trouble. And so typically then Florida would probably send some officers out. In Iowa, we probably wouldn't send 4 officers.
It was a murder case. It had been a
Right.
cold
Yeah.
case for 3 years.
Yeah.
They knew this was going to be the one
Yeah.
crack at the guy. The guy's a drifter. They had trouble finding him. They knew that he was liable to disappear again
Right.
as he had disappeared before.
Right, might run.
They would have been subject to a lot of criticism, I think, wouldn't they, if they had not made arrangements, precautions? They only had two in the room talking to him, right?
At the scene where they went out to his trailer, yeah, if he'd have come out with a gun or if he'd have fled, it would have been quite embarrassing to say, well, yeah, we only had a couple officers there. And
What would be the practical problems if we held the right to counsel attached pre-arrest in this case, if that's how we interpreted the Iowa constitutional requirement of a case or criminal prosecution to reach this far back?
Well, there are a lot of them, but let me focus on one in particular that's unique to this case, because this was out of state. There's no procedure, no statute, no procedure, nothing that authorizes a Florida judge to appoint counsel for an Iowa suspect. Conversely, there's nothing in Iowa which would allow Iowa judge or to appoint a Florida attorney to represent the suspect. So there's just really no way to implement that.
So the prosecutor just doesn't participate in the interrogation in Florida? I'm not sure, but I'm not sure I've heard anybody say, well, a police officer doing the interrogation would have been a problem.
But I think the defendant's argument, though, is it wouldn't only be confined to situations where the prosecutor did the interrogating or involved in the interrogating. That under Mr. Green's proposed test, if the focus was sufficient, even if there was no arrest, Mr. Green would have a right to counsel, whether or not the prosecutor.
Oh, that's going to be a hard.
Yeah.
That's going to be a hard road to
Yeah.
hoe, probably.
Well, I think it shows the problem with the functionality test is there are so many different factors that can come into play in so many different situations that the average law enforcement officer is going to have no idea whether there's a right to counsel under Article 10 or not. In order for the right to be effective, it has to be implemented, and for it to be implemented, somebody, the guy on the street, the woman on the street, has to know how to do that.
How about when the focus?
Well, we deal with that kind of multi-factor analysis in the Miranda issue. Why couldn't we deal with it in the right to counsel issue?
We do, but it's a little more limited. Custody is a pretty narrow issue, and a lot of whether there's custody or not is controlled by the law enforcement officer. If the suspect is free to leave and the officer makes that clear to the suspect, the officer is assured most times that there's no custody. Conversely, under a functionality test, under Article 10, a number of factors would come into play, almost none of them under the control of the officer, and frankly, many of them not even known to the officer. So it would be really, really difficult. Also, I think we need to remember that, go back to the purpose of Section 10, which is, again, to ensure a fair trial. There are other protections, the Fifth Amendment and the Iowa equivalent. They don't have a direct equivalent, but the Due Process Clause is incorporated the Fifth Amendment. There are other protections. We've got the statutory right, but this Article 10 is focused at trial. And while there are other things that we could think about, we have to remember that solving crimes is a social good. And there's nothing in the history or the language of Article 10 that says that the framers were trying to limit the right to investigate crime.
Chief, can I ask one more question, please? I just out of fairness, because we did talk about the instruction a little bit, and I'd like to give you an opportunity. The problem, it seems to me, to the extent there is a problem, is this. Under the defense theory, there was a scuffle involving kind of either chair leg or, table leg or baseball bat or something. And that apparently the cause of death was use of some kind of implement. But can you infer malice solely from the use of that kind of item? I mean, it's not like a gun. I mean, you take a gun to a bar and you can probably infer that this is no good. But according to the defense, at least, this is a milder situation where an inference solely based on a table leg or a bat would be misleading. I invite your response.
The short answer is yes, you can infer malice from that. And here's why. He was convicted of second-degree murder, so there's no premeditation requirement. And if you look at the definition of a dangerous weapon, it's instrument or device which is actually used in such a way as to indicate intent to inflict death or serious injury and capable of inflicting death when so used. So it's not like the jury was allowed to infer malice from a freak use of a, something that wouldn't maybe be intended to kill. In order to find a dangerous weapon, which is then incorporated into the other instruction, they have to find that it was used in a manner indicating an intent to inflict serious injury or death, and that is malice. So at least as for second-degree murder cases, I think it's completely okay. If there are no other questions, thank you.
Ms. Chambers, thank you. Ms. Nye, rebuttal argument? Could just begin with picking up on the jury instruction on implied malice.
Yeah.
I know that we use the example of provided by Professor Rigg of two people get into a fight. One guy's getting the tar beat out of him, and he picks up a rock off the ground and hits him, hits the person, the victim, and he dies, charged with murder.
Yeah.
Question is whether use of the rock can be implied malice. And you sort of build on that premise in this case.
Yeah.
But as Justice Apple mentioned, we have a baseball bat in this case, and there isn't any evidence that Green picked up the baseball bat and whacked the victim and killed him, but that he took the baseball bat, put it against his throat, and pressed against his throat for at least 2 minutes. Consistent with the medical evidence in the case, that would take you 2 minutes to choke someone to death with a baseball bat. Can't we use the implied malice instruction under those circumstances?
I think no. I think the problem with them is even allowing for this, the time that it takes to choke someone out. When you're in a justification, a self-defense situation, it's not as clear that time to deliberate, that time to think, is being used is necessarily being used to think about what damage is being done and what the harm is. It's just as there's a lot in a justification situation. There's a lot of other things to think about. Do I have another way to get out of here? Why is my friend attacking me?
Well, let's just say it. It'd be a minimum of 2 minutes because I think the medical expert said that if there was any point during that 2 minutes where the bat would have been off the trachea, so he would have got some air, or it would have been taken any longer. But let's just assume it was 2 minutes. And let's assume that for the first minute, Green was really struggling and fearing and reacting like Professor Rigg's instinctive example. But at some point, don't you, what about the second minute? He's still pressing against the guy's throat for another 60 seconds before death occurs. At some point in that 2 minutes, couldn't the jury be permitted to say that the use of that bat, you could imply that he had the ill will to result in second-degree murder?
I think that's fair for the prosecution to argue that, and certainly they did. The problem is when you instruct the jury on it, when now it's, we've got this justification, a viable justification defense at play.
But the instruction wasn't mandatory.
No.
It's
true. It would certainly be worse if it were mandatory, but
not even the instruction requires more than the use of a dangerous weapon. It said if a person has the opportunity to deliberate and uses a dangerous weapon, you can infer malice.
Right.
So in order to even draw this permissive inference, they had to find the situation like the chief was referring to, that there was an opportunity to deliberate. It is not an inference being drawn solely from the use of a dangerous weapon, which I think might be more problematic.
Definitely, if they'd gotten the correct instruction, if the malice had been, this was sort of a merging of two uniform instructions, and so it added this element. But I still think that it comes into, as I was saying, with the opportunity to deliberate. Just because there was that time doesn't necessarily mean that that's what the person in a justification situation, in a struggle, was thinking about. And
Unless they found an opportunity to deliberate, they would not have been able to rely on that instruction, right? That's what it said.
that's the way it's worded. But the problem, even though it's permissive, the problem is, again, like I said, it sort of spotlights, it highlights a particular piece of the state's case that there could have been an instruction that said you can also infer that he didn't intend to deliberate, but instead it focuses in on a piece of evidence that supports the state's case and elevates it to an instruction, when the jury's already told it can make inferences based on the evidence. And so that's where the real problem comes in on it, is that it's subtly sort of reinforcing and influencing the state's case.
Okay, I think we sidetracked you, so if you want to take a minute and sum up if you had some rebuttal to
The
make
only
in
thing, I
addition.
just wanted to point out that there's nothing magic about the filing of a complaint or a trial information. They can, we use this test to say that the state's committed to prosecute. The state can withdraw a complaint, can change I just saw this on the news the other day, they decided they had the wrong person and withdrew a complaint and charged someone else. So, that's, this sort of bright line rule is not as bright line. Would that mean, even though this complaint had been filed? So it really has to do with the circumstances and the commitment to prosecute, the forces of the state being focused on the defendant. And also, I think it was discussed in Sen as well that just because the purpose of the right to counsel is to protect trial, to ensure a fair trial, that doesn't just mean you get an attorney that shows up in trial. The rationale is that you need the assistance of counsel in more outside of the trial, outside of the courtroom, and so that supports finding that a criminal prosecution may commence before formal charges are filed. So, for the reasons argued today and in my brief, we ask that you reverse Mr. Green's conviction and remand for a new trial with instructions. Thank you.
Ms. Nye, thank you. The case of State versus Green is now then submitted to the court, and we'll next hear the arguments in the estate of Cox.